Well, it's another lawyer behaving badly. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a Florida lawyer who I guess got mixed up as to who the client was. Let's talk about it down at the beach. It's only fair, it's Florida, right? There are basically two kinds of lawyers when it comes to the ethical rules. And they are those who take their ethical obligations seriously and those who simply do not take their ethical obligations seriously. Sometimes the ethical obligations are not always clear. For example, when you have a corporation, the corporation is the client, not the individual officers. In many respects, it may feel like the officers are the clients, but they're not. It's the organization. And you can see where somebody can get a little confused in that regard when they're trying to do their best, because you never make friends with a corporation. You only make friends with the people in the corporation. And the people who hire you are the people in the corporation, even though the corporation is the client. So you can understand sort of how a lawyer might get flummoxed in that regard, but if they pay attention to the legal rules, they know that they have to give true faith and allegiance to their client. It is the client who controls what happens in litigation. It is the client who controls the objectives of litigation. And as a result of that, you have to do what the client wants done. In this particular case, we have a lawyer who works in the area of eminent domain. And eminent domain, of course, is where the government comes in and says, you know, that tract of land that borders Highway 50 there, I think we're going to need about 100 yards of that to put a new road in. And we'll pay you something for it. Now, obviously, it's the property owner's job to get as much compensation as he can, and it's the government's job to pay him as little as they can. And it's the attorneys on both sides, the one for the agency that wants the land, whether that's the Department of Transportation, as it is in this case, or whether it's, the National Guard, whatever organization it is that wants this land, well, they have to pay for it. And again, it's done through attorneys. And it's also, it involves expert witnesses coming in and saying what the value of that piece of land is. And it can be a long and difficult process. It tends to be one of those where the government can and often does pay the attorney's fees of the party that they're opposing in order to get a settlement that everybody can live with. In Florida, they actually have a statute directly on point that says we will pay the attorney's fees of the person whose property has been condemned. And so we know that the lawyer knows when he goes in that he's going to get paid something. Now, a lot of times the fees that are determined are based on an hourly fee, but sometimes they can be determined by a percentage. And in this particular case, there was a percentage issue involved. But in just a second here, we're going to look at the language of the opinion and hopefully have an opportunity to go into a little bit of the inside baseball in this particular case as to why it came out the way that it did for this attorney who clearly stepped over the rules here. Let's take a look at the case now. The Florida Bar versus Brian P. Rush. This was handed down on May 4th, 2023. It says, Respondent Brian Rush seeks a review of a referee's report recommending that he be found guilty of professional misconduct and suspended from the practice of law for 3 years for failing to follow his client's directives and placing his personal pecuniary interests ahead of his client's stated goals. Rush challenges the referee's findings of fact and recommendations as to guilt, arguing that his conduct did not violate any of the rules regulating the Florida Bar. He also asserts that he's not guilty of misconduct and should not be sanctioned and assessed bar costs. We disagree, and for the reasons discussed below, we approve the referee's report in its entirety and suspend Rush from the practice of law for 3 years. Now, one of the things that Florida does, and I think they do quite well, is they never bury the lead in any of these cases. They always tell you up front what the result is going to be. And that's so that people who get these opinions, particularly a lawyer like Mr. Rush, doesn't have to page through 22 pages worth of data to find out whether he's going to be suspended or not. But it's interesting here in that they sort of preface everything that happens in this case by pointing out that he put his interests above his client's interests. And at the end of the day, that's really the sin that they are addressing. There are other things too, but the thing that I think really got the referee's attention here is the way in which he put his own interests, his own financial interests, above those of his client. So let's continue. North Park Isles and JT North Park, collectively North Park, are both limited liability companies, and they were owned by 3 managing members, Todd Taylor, Jack Suarez, and Bob Suarez. North Park owned property in Hillsborough County, which is where Tampa is located, that was the subject of an eminent domain action by the Florida Department of Transportation. North Park and FDOT reached an agreement to relocate a planned drainage pond on the property. In anticipation of further litigation, Taylor hired Rush in 2014 on behalf of North Park. Taylor signed a fee agreement stating that Rush's legal costs and expenses would be paid by the state of Florida and FDOT. The agreement also stated that if legal representation was terminated, North Park would be obligated to pay the reasonable value of Rush's services. A lot of times in contingent litigation, lawyers will put in a clause that basically says, you know, if you take action that will affect my ability to get a fee, I have the right to get a fee through what's called quantum meruit, which means as much as the thing is worth. So a lawyer who does work on behalf of a client becomes entitled to a fee, and he has a lien for that fee against whatever property is at issue in the case. But what a lawyer can't do is leverage that fee against the client's interests. So stay tuned. In October of 2017, the Circuit Court entered an order of taking for the North Park property, necessitating a determination of compensation for the taking. And for those of you who don't know, this arises out of the Fifth Amendment. No property may be taken without just compensation. So the state of Florida wanted some property, perhaps to rebuild a road or do something like that, and they had this property and they decided to take it. So now there has to be a determination as to how much compensation North Park is due. So Rush argued that the current placement of a drainage pond would restrict access to the land, destroying its developmental value, but that FDOT could move the pond and restore about $8 million in value to the land. This would constitute a non-monetary benefit, and the enhanced value of the land would entitle Rush to an award of statutory attorney's fees. Initially, North Park went along with this, but in the spring of 2018, a guy by the name of Hills got financing approved, but the bank would not fund closing until the eminent domain case concluded. At that point, North Park's objectives changed, and Rush was told that the goal was to settle the eminent domain action quickly to facilitate the sale of the property. Thereafter, Rush began filing a series of unauthorized pleadings and motions in the eminent domain case, seeking to preserve and advance his claim for attorney's fees based on his non-monetary benefits argument. So North Park met with him, and during the meeting, Rush reminded North Park that termination of his services would make North Park responsible for paying his fees. When asked about the approximate amount, he told them that it was between $300,000 and $1 million. Though North Park no longer wanted Rush to pursue his argument, it was afraid to terminate his representation because of the potential liability for $1 million in fees. North Park emphasized again that the pending sale was the priority and that it needed to close by the end of April 2018. North Park enlisted its real estate counsel, Richard Pettit, to assist in getting Rush to settle the eminent domain case. But Rush continued to file pleadings with the court that advanced his argument for non-monetary benefits. Then, prior to consulting with North Park, Rush sent FDOT a settlement proposal waiving monetary benefits in favor of Rush's non-monetary benefits argument. In mid-April 2018, at North Park's urging, Pettit filed a notice of appearance in the case, and he instructed Rush not to file anything further without obtaining consent communicated through him. But in spite of this, Rush continued to file pleadings seeking approximately $1.4 million in fees based on his argument for non-monetary benefits. Rush's unwillingness to cooperate with Pettit ultimately resulted in the circuit court becoming confused as to who was representing North Park. It refused to rule on any pending motions until the issue was resolved. Based on prior interactions with Rush and safety concerns, the FDOT attorney, Eloima Sanchez, brought Philip Hobby, an independent contractor, with her to a hearing in July of 2018. After the hearing, Rush was very angry and threatened to sue Sanchez for tortious interference of his fee agreement with North Park, accusing her of scheming to defraud him, and he threatened to file a bar complaint. Later, Rush admitted he threatened to sue Sanchez, but denied threatening to file a bar complaint. Because of this interaction, FDOT refused to reach an informal settlement with North Park and insisted on a formal mediation or trial to have a third-party oversight. Unable to clarify the representation issue, Pettit sent a client-approved settlement offer to Rush to sign and submit to FDOT, specifying that there be no modifications. Fearing that the wording of the agreement would constitute waiver of his attorney's fees, Rush altered the language without first consulting or informing North Park or Pettit, and submitted the new version to FDOT. After this unauthorized submission, North Park terminated Rush's representation, and he withdrew from the case, though the court retained authority to determine his fees. In August 2018, Rush sued North Park seeking fee arbitration and raised 21 causes of action. They were all denied in a detailed 32-page order. Then he filed 2 liens pendens, and this is a situation where you file a notice and it gets posted in the property records that there's litigation concerning the property, and it encumbers the property, and no bank is going to give you financing on it when there is this lien basically it's been placed on the property. But because Rush had no recorded interest in the subject property, the court dissolved both liens pendens. Rush then filed another lawsuit against Hills, the property purchaser, the individual who had previously held the purchase agreement, and the bank financing the purchase. In November of 2018, North Park and FDOT reached a settlement after former mediation, and that did not include relocation of the drainage pond. The stipulated final judgment was entered in January, and FDOT paid North Park the monetary value of the property taken and the expert fees. Rush, however, continued to seek fees based on its non-monetary benefits argument, despite that agreement. He claimed that they had engaged in a conspiracy and called the stipulated final judgment fraudulent and a sham, and he attempted to have it undone. Based on the above findings, the referee recommended that Rush be found guilty of violating Bar Rules 4-1.2, Objectives and Scope of Representation, 1.4, Communication, Fees and Costs for Legal Services, 1.5, 1.7, Conflict of Interest, 3.1, Meritorious Claims and Contentions, 3.4, Fairness to Opposing Party and Counsel, and 8.4, Misconduct. The referee found 1 mitigating factor, that he had never been disciplined before, and 5 aggravating factors, dishonest or selfish motive, bad faith obstruction of the disciplinary proceedings by demonstrating improper and unprofessional behavior throughout the disciplinary process, refusal to acknowledge the wrongful nature of the conduct by showing no remorse and portraying himself as the victim of illegal conduct by others, substantial experience in the practice of law, having been admitted in 1982 and representing clients in eminent domain cases since 1987. The referee recommends that Rush be suspended from the practice of law for 3 years and be assessed bar costs. So you've got a client who says, I want to sell this property. I want you to get the eminent domain thing done. And you got a lawyer who says, I don't care what you want. I want my fee. I want my $1.4 million fee based on this ridiculous idea that I can get non-monetary benefit for you. And the client says, I don't want that. It's changed. Things have changed. Now I want to just get this thing done with. And instead of taking a clue here and saying, hey, maybe I ought to listen to my client because, when you get right down to it, he really is paying my fee. He doesn't do that. Instead, what he does is he continues to pursue in a pig-headed manner his own personal and unprofessional pursuit of these fees. And he should know as an attorney that he can't do that. In fact, I'm pretty sure he does know that as an attorney he can't do that. If that wasn't bad enough, he then doesn't cooperate in the disciplinary process. He is unprofessional in the disciplinary process. He doesn't show any remorse. He obstructs the disciplinary process. And he winds up getting hit with 5 aggravating factors. Now, as a result of his actions, it's pretty clear that North Park lost money. In other words, had they sold it to Mr. Hills at the time that they were trying to sell it to him, they probably would have made more money than they did based on the eminent domain being settled through mediation, which is probably something that the lawyer, Mr. Pettit, handled. It is pretty much an unconscionable thing for an attorney to put his own interests above those of his clients. And it's almost a guarantee that if you do that as a lawyer, you are going to get sanctioned and you're probably going to get hit with a pretty stiff one. And indeed, that's what is going to happen here. Now, the opinion is 22 pages long, and I could go through. First, you can't put your own interests above those of the client. Second, you can't charge an unreasonable fee. And when you base your fee on non-monetary benefits that you do not obtain, that's unreasonable. And to tell the client that you're going to ding them for that fee when you didn't get them that non-monetary benefit, that's just completely nuts. And I don't understand why he didn't come to the bar with his hat in hand and say, you know what, I really screwed this up. I just got a little pig-headed. I shouldn't have done that. My mistake. But instead, what he comes in and basically takes the approach that the first liar doesn't stand a chance. He's going to come in there and tell him that he didn't do anything wrong, that he thought he was operating off of the initial set of instructions to get non-monetary benefit, when that is obviously just not the case. And the evidence wasn't there for that. And that's what the referee found. And as a result, he recommended a suspension for 3 years. Now, in other states, this lawyer might very well have been disbarred. But here they suspended him for 3 years. Now, what that means is he can't practice law. He can still do legal research for other lawyers. He can write memos. He can act as a paralegal. He can do something to earn money. But he can't practice law. He can't go into court and represent someone. He can't draft a will. He can't really do much of anything that is legal work. And if he does, and the bar finds out about it, then he's going to wind up getting disbarred. So he's got a real problem on his hands in terms of making money in the future. And I'm sure that may have impacted his desire to take a more aggressive approach with the bar discipline folks. But as you can see, it clearly did not work out. the Florida bar reached its conclusion, and I'll show you what it is. We agree with the referee that Rush's deliberate disregard of his professional obligations warrants a severe sanction. We conclude that the recommendation for a 3-year suspension has a reasonable basis in the standards, and as a result, they come down here and they say Brian Rush is hereby suspended from the practice of law for 3 years. The suspension will be effective 30 days from the filing of this opinion, so Rush can close out his practice and protect the interests of existing clients, basically by moving them to other lawyers. And if he notifies the court in writing that he's no longer practicing and does not need the 30 days to protect his clients, the court will enter the order making the suspension effective immediately. So, in addition to that, they dinged him for $19,761.47 in recovery of costs from the investigation and the other attendant bar discipline proceedings. So not only is he not going to work for 3 years, he's going to have to pay almost $20,000 to the bar to settle up accounts with them. Well, that's what I have for you today. It's probably not as funny a case as the other ones are, but you can certainly see how this guy got off track, and that in so doing, he wound up harming his client first, and then he wound up hurting himself. It is sad when people who know better don't do better. And so I'm hoping that Mr. Rush can get his life and his act together in the next couple of years and come back and be a functional member of the bar. Again, that's what I have for you. Thank you so much for watching. If you have the opportunity today, try and do something kind for someone else. And I will catch you next time down here at the beach. Have a great day, my friends. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.